Trust and wills are similar in that both are your written instructions of who gets your assets when you die. They're different in the way that they're handled while you're alive and after you die. A will is not legally enforceable while you're alive. When you die, a will is governed by a court process called probate. That process takes about 2 years and invokes statutory fees. A trust, on the other hand, is legally enforceable while you're alive, is enforced after you die, is completely private. It doesn't go through the court process unless you ask it to, and there's no statutory fees involved. So for most people, a trust is preferred. You should make your will when you turn 18. When you turn 18, you're considered a legal adult, and at that time you should start thinking about who should get your assets if you die. That said, you might not actually be the best fit for a will. Maybe the best fit is a trust. Why? Because a will is governed by a court process that can take up to 2 years and invoke statutory fees. If you had a trust, you would have ultimate say over who gets your assets and when. You know you need a trust if you have any of the following. You own real estate in any state. You own a business. You have children for which you want to leave age-restricted gifts. If you value the privacy of your assets and your beneficiaries, and if you want ultimate say and control over who gets your assets at death. After you create a trust, your assets are still in your control. And while you have capacity, you maintain control and ownership of all of your trust assets. The IRS even calls this an invisible look-through. So really, after you set up a trust, you'll notice no changes. You will know your trust is enforced when you die because the person that you choose to be in control of your trust should follow your wishes. How do you know they're going to follow your wishes? Well, you need to choose the right person. You need to choose somebody who's comfortable with making a lot of tax decisions after you die, with someone who has the time and experience to make decisions for you, who has the ability to make sure that your beneficiaries get the right distribution. And say you pick the wrong person, then what happens? Well, the rest of your beneficiaries are able to go to court and ask the judge to either remove that person and put in your second choice or third choice person, or maybe at that time put in a corporate fiduciary if you don't have an individual that can make the decisions for your trust. There are 2 things to do to prepare to meet with an attorney about estate planning. First, look around your house and bring all your old estate planning documents and real estate documents with you, even if you think they're old or have been revoked or are somehow no longer valid. Why? Because we need to see what you have out there already to know where we should begin or start over or continue. And the second thing is, and maybe more importantly, bring all of your questions and concerns. If there's something that keeps you up at night, for example, a capacity issue, aging parents, or children with addiction issues, or other issues in your family that you think might cause problems or litigation in the future, make sure that you can raise that with the attorney. When I meet with clients, will always ask some tough questions just to make sure that I'm not missing something, so that your estate plan is complete and that you can rest assured that your family and your beneficiaries will be taken care of when you pass away. So what we like to say is, if you can bring your documents and all of your questions and concerns, by the time you leave, you'll have peace of mind. That's the nature of our business, peace of mind.